Good afternoon. It's wonderful to see all of you here for the 11th annual James M. Nabrit Jr. Lecture Series. It is with great pleasure that the Howard University School of Law joins with K&L Gates to present this 11th annual lecture series in honor of an extraordinary individual, Mr. James Nabrit Jr., who is considered to be one of the leading constitutional and civil rights lawyers of his generation. Please read the bio on James Nabrit in our program. James Nabrit Jr. was a graduate of Morehouse College and Northwestern University Law School. He joined the Howard University School of Law faculty in 1936, and then in 1938 he created what is believed to be the very first civil rights law class in the nation. In the 1950s and 1960s, Mr. Nabrit litigated cases for the NAACP Legal Defense Fund alongside Charles Hamilton Houston and Thurgood Marshall. Nabrit's most famous case is probably Bowling versus Sharp. How many people have read Bowling versus Sharp before? Very good. So Bowling, of course, is the companion case to Brown versus Board of Education, which was decided on the basis of the Due Process Clause of the Fifth Amendment, and Nabrit and George Hayes won that case on behalf of their clients to won that seminal case on behalf of their clients. He went on to become the dean of this law school from 1958 to 1960, and then the president of Howard University from 1960 to 1965, and then again from 1968 to 1969. So we are so honored to be able to celebrate the legacy of James Nabrit through this lecture series and with our partners K&L Gates. First, I'd like to acknowledge a few special guests that are here in the audience. I'd like to acknowledge the Honorable Judge Emmett G. Sullivan. If you'll please stand, District Court Judge from the United States District Court of the District of Columbia and son of Howard, graduate of this law school. Thank you so much for being here, Judge Sullivan. I also wanted to acknowledge Judge Alexander Williams. Is he here? Is Alex Williams here? Okay, maybe not right now. Okay. And also, I'd like to acknowledge all of the alumni of Howard University. If you'd please stand up, all of our alums of the law school who are here, all of the alums of the university. Thank you so much for being here. I also want to point out Robin Chan, who's here in the audience, who is a representative of not just Howard University School of Law, but also one of the clerkship family, one of Judge Stewart's many law clerks, and who is here in D.C. now. Next, I would like to introduce the members of K&L Gates, if they are here, the members of the law firm of K&L Gates, and to thank them for all that they have done to sponsor this series. Their support of the Nabrit program has assisted us in bringing to this campus distinguished jurists from the state and federal courts, senior executive branch policymakers, members of Congress, and leading academic scholars. Also, the firm has been a true pace setter in establishing the position of Chief Diversity Officer, a practice that has been adopted by other national law firms. Through hiring and mentoring practices, civic engagement, and academic support, K&L Gates demonstrates why it is considered among the very best in the legal profession. So at this time, I would like to bring forward Mr. Paul Sweeney, who's Administrative Partner and Diversity Committee Chair of K&L Gates, Los Angeles. Thank you so much, Mr. Sweeney.
Well, good afternoon and welcome. Let me begin by thanking Dean Holly Walker for putting together another great program here at the 11th Annual James M. Nabrit Jr. Lecture Series. Today, you're going to have two outstanding speakers. First, you're going to hear Judge Carl Stewart of the U.S. Court of Appeals for the Fifth Circuit. And later, you'll hear David Wilkins, who is a professor at Harvard Law School. Over a decade ago, our law firm decided to partner with Howard University Law School to commemorate the legacy of James M. Nabrit Jr. As Dean Holly Walker told you, you know that Dean Nabrit was a civil rights legacy And he was an architect, one of the architects of the decision in Brown versus the Board of Education. We have been very, very proud to work with the law school in ensuring that every year we can put on an outstanding series of speakers. And as mentioned, over the years, we have had just the best speakers. We've had U.S. Supreme Court justices, U.S. Court of Appeals judges, state Supreme Court judges, assistants to the presidents, special advisors to the president, congressmen, civil rights icons, and law professors, all of them. If you look in the back of your program, you will see over the years the number of speakers that we've been able to present here. Hopefully, for those of you who have come in the past, and for those of you who come today and in the future, you will find that this helps to enrich your legal education here at the law school. On a more personal note, let me mention that the connections between Howard Law School and our law firm run very deep. We have graduates from the undergraduate school at our firm, from the law school, and people like me whose parent graduated from the law school. My dad graduated in the great law school class of 1954, the year that Brown versus the Board of Education was decided. And I remember him telling me about sitting in on strategy sessions where they brought the students in to talk about the arguments to be made before the Supreme Court. So with that, let me say again, we are very, very proud to support Howard Law School, and you, the students and the faculty. We hope that you will enjoy the day's programs, and we are very proud to be your partner and your sponsor. Thank you very much.
Thank you so much, Mr. Sweeney, and thank you again to K&L Gates. So I will take the privilege of introducing today's speaker, Judge Carly Stewart, who is the Chief Judge of the Fifth Circuit Court of Appeals. Chief Judge Carly Stewart is many things. The first is he is a distinguished jurist. So he was appointed on May 9th, 1994 by President William J. Clinton to the United States Fifth Circuit Court of Appeals. He then became Chief Judge of the Fifth Circuit Court of Appeals on October 1st, 2012. As you know, the Fifth Circuit encompasses Texas, Mississippi, and Louisiana, and Judge Stewart is based in Shreveport, and the court's main work is done in Louisiana. Judge Stewart is also a leader in the legal community. He serves as a president of the American Inns of Court Foundation. He is a member of the American National, Federal, Louisiana, and Shreveport Bar Association and the Federal Judges Association. He is the past chairman of the Advisory Committee on the Federal Rules of Appellate Procedure of the Judicial Conference of the United States, and he is also a member of the National Bar Association Judicial Council. Chief Judge Stewart also serves on the Centenary College Board of Trustees. The Chief is also a servant leader. He is a frequent speaker and volunteer at area schools. He has received several commemorative awards as a result of his civic and community involvement. He's also been long involved in the Boy Scouts of America. He is also a devoted husband to his beautiful wife, Joanne Stewart, and a loving father to his 3 children, Carl Jr., Kyle, and Corelia, who is now herself a state court trial judge. And he's also a grandfather and dotes on his grandchildren and gets to indulge his passion for photography by taking many, many pictures of his grandchildren. But most importantly to me, he is a mentor. He is a mentor and supporter of all of his law clerks. I had the privilege of clerking for him from 1999 to 2000. And since we met when I was a 2L law student, which was many, many years ago, he has become my mentor and one of the most important people in my life in terms of guiding my professional career. I will never forget our interview when I interviewed for my clerkship with Judge Stewart. And I wondered why he wanted to interview me. I was from Houston, Texas, but I couldn't figure out what other connection that we had. And it turns out that the connection that we had was Charles Hamilton Houston. So I'd written my senior thesis on Charles Houston. Judge Stewart is an avid history buff and wanted to talk to me about my Houston thesis. So that shows you that when you apply for these clerkships, you have no idea what will interest the judge that is on your resume. Since that time, at every turn, he has been a supporter and a friend. Every job that I've taken since law school, I always call him and ask him about my next move. And unfortunately, he spent a good deal of his free time being a recommender for all of my various jobs that I say, and he does it all with a smile. I've sought out his advice often, and he is always there, and he's always there to answer the phone when I need a favor. I've learned so much from him. He is one of the top judges in the United States, but he's humble. So just now, he's talking to everyone who comes in the room, and I've learned that that is an important characteristic as you rise in your career. He always takes time for family, friends, church, and community, and he is a person of tremendous integrity. So I'm honored to introduce to you Chief Judge Carl E. Stewart.
Thank you so very much for that wonderfully warm introduction. It's just indeed an honor for me to be here at Howard. The history and all that goes with Howard is just enveloping. I've just appreciated walking through and looking at the photos, and just there's so much history, so much inspiration. This is a place, just to me, just walking through here every day, one should and ought to be inspired just being here. So I'm honored to be here for this lecture. I thank Dean Holly Walker for that very kind and generous introduction. I'm honored to be here. I'm well aware of the long list of prior lecturers that you've had here, and I'm just honored to be added to that list of persons who've been given an opportunity to share some thoughts with you. It's a pleasure to be in Washington, D.C., particularly when the sun is shining, as opposed to last week when, the sun's out. I'm a Southern guy, and, I don't do well with the slick snow, so it's really a pleasure, even though I'm still suffering from having lost my hour for daylight saving time and lost the hour for Eastern time. So, I'm kind of 2 hours back, and I'm looking forward to getting home so I can catch up on my time. But that said, I appreciate being here. Let me, in addition to thanking Howard for maintaining this wonderful lecture, to also, as I said to them privately, to the gentleman from K&L Gates for supporting this, because this is really what's needed, is for corporate America to step forward out of the shadows, to be proactive, to lead the way, to be mentors to their own kind of colleagues of what the right thing to do. Many of you read the piece probably yesterday, about Apple. It ought not to take all this urging. People ought to do the right thing because it's the right thing to do. But whether urged or not, we're pleased to see corporate America do it. And I think with K&L Gates and Apple and others, to really step forward to do the kinds of things they should do and ought to do. And while we applaud them for doing it, it's really like applauding people for doing what they ought to do. It really is not extra. And so I appreciate personally, on behalf of my court and just the profession, what your firm has done. As I said to them, we applaud Kim Askew, who's a partner in the Dallas office of K&L Gates. She's just an absolute star lawyer. She specializes in complex litigation, commercial, and employment. And Kim was recently awarded the 2015 Spirit of Excellence Award by the American Bar Association for her work in promoting diversity. And if you want to have some tears drip, go to the ABA site and listen to and watch her acceptance. If it doesn't bring tears to you, it ought to, but you will see an awesome lawyer. And so we appreciate her and are glad to have her in our circuit. And I know that she's proud of what you're doing to support this lecture series, and I'm proud to know her and to spend time with you. This is a wonderful opportunity to really pay homage to a constellation of pioneering legal stars whose passion, whose dedication, and humanity and perseverance have led us this way. I want to just say how much I treasure Danielle's having clerked for me in 1999 and 2000. Emmett, this isn't D.C., this isn't Houston. Clerks want to go to Houston, they want to go to D.C., they want to go to New York. I mean, they ain't exactly, Shreveport's not on their bucket list, you know, to come clerk. You know, I get that, you know, but they get a choice, you know, they go on to the big city, to Houston and all of that stuff. So to get the good clerks to come to medium-sized, small, you know, you kind of gotta, you know, you gotta work it a little bit to come. Now, these things are coveted. We get hundreds of applications, literally, but people want to clerk at the federal appellate level. And if you wonder why, look under the name of anybody who's out there, and you'll see there was somebody's clerk. Chief Justice John Roberts was the clerk of William Rehnquist. You know, all you got to do is look and see people have been clerks. It's a stepping stone. So it's not just something extra to do. It's value added and measured. So we get hundreds, and I'd probably say thousands of applications from clerks, and everybody's bright. You know, they all got all A's, and they were the valedictorians and all that kind of stuff. It's difficult to sort through who's who. So in looking at all these things, some of my colleagues, they give them to committees. They had the law clerks do them and all that kind of stuff, and they winnow it down. Me, I'm not into that. I'm picking anybody I'm bringing into my chamber to work a year. I put my own 10 fingerprints, my own eyeballs. I'll accept all my successes and all my failures. I'm not giving to some committee to pick some law clerk that's going to be with me. So I do it. I got some colleagues now want to do the video interviews to save the clerks money from flying. I'm like, no, you're going to leave my chambers making more money than I do. And, you know, you're not going to spend a plane ticket to come interview? Oh, no, it ain't happening. Go to Houston, go to Emmett. You know, you ain't got to travel. But if you come in here, you got to come to Shreveport so you can figure out, yeah, this place, fine. I'd rather you turn the job down. So that said, when I saw the resume of Danielle Holly, you know, knowing that she had a wonderful education from Yale and Harvard, great grades, et cetera, it was evident to me, oh, she's not going to last long. She's going to be gone to her. The first person who interviewed her, you know, they're going to hire her. So I hope I didn't say something to send them back. I ain't even got it started yet. I've never had people get up and walk out when I'm still warming up. But in any event, I knew that she would not last long to come. And so when I looked at her credentials, but more than that, I knew that there was something special off of that paper. There's some people that you look at the resumes, they literally jump off the paper at you, and you know that there is something special. But I did know that if I didn't interview in a hurry, you know, she would be gone. And so I did cast out a net. I think our geographical location helped. She's from Houston. Houston's 224 miles southwest of Shreveport. It's an easy drive. You know, no time zone, no issues. So put her on the front burner. I think I might even call and said, hey, don't you want to come interview? And so she gave you that side of why she wanted to, but I know she's going to be gone quickly. And so she came and she interviewed and so forth and all that. And I say that because really, I say, there's no doubt, I've said it for 20 years, I've been a judge for 30 years. The greatest part of my job as a federal judge is working with my law clerks. It's not the opinions I write, it's nothing else I do. The greatest part is working with these law clerks. And so, bar none, I look forward to it. It's a wonderful experience of mutual mentorship, and I wouldn't trade anything. Your opinions can get overruled. They go in the dustbin. People forget about them, etc. But the wonderful legacy of law clerks who go on to do great things out here, that's what brings me great pleasure. And so suffice it to say, once we went through the interview and so forth, I was interested in knowing something about the person. Everybody's smart, but it's a person. And so as we dug through it and so forth, it was clear to me that she had the kind of people skills and the wonderful acumen that she would be successful whether she clerked for me or not. So I'm not suggesting because she clerked for me, success was there. But it was evident that that she would be successful. And so I did hire her and had a wonderful experience with her in there. And so that's why it's not been an issue whenever I've had somebody call for a reference. I don't need to dig up a personnel file. I don't need no notice. I don't need somebody to send me the sheet. When did she clerk for me and all that stuff? They can call me at 3 o'clock in the morning on any of my law clerks, Robin, Daniel, or whatever. And I can give the reference from that because that's just how close I get to them and know their work to be able to give a reference. I probably had her walking on water more times than a few. She might have almost lost some jobs because they figure, oh, this person can't be as good as he's saying. But anyway, I mean, that's the mark of you do a good job in the chambers. A good old judge will take good care of you out into the future. So at the end of it, if you clerk, it's worth its weight in gold. So this is a premium pleasure for me to be here. to share in this, the first of the lecture she's had. I chose as a topic after talking to her, cultivating the legacy of civil rights era giants. And I want to spend some time, and I'll try to not hold you beyond this sign time, but I wanted to talk about this as we pause and consider, because when I thought about it, I mean, we're today, March the 12th, we're in what I call a reflective, commemorative era. You know, we've kind of, as a collective society, hit the pause button, if you will, in our otherwise frenzied lifestyle in order to reflect, to commemorate, to learn from, and hopefully recommit to many important principles and ideals that are milestones in our history. For my generation and older, these reflections trigger a range of thoughts and emotions. Some of these are very painful about the times past and the paths that we and our ancestors have trod. For my children and for those who are younger, this is like new news. You know, this is a brand new deal. What are y'all talking about? You know, this is not. But movies like Glory and Lincoln, 12 Years a Slave, The Help, The Butler, and last week's Selma. I mean, I sat in the movie as blacks and whites are watching these movies. Some of the white folks are like, I can't believe it happened. I mean, they're embarrassed that this all happened. And then there are others think this is like something Steven Spielberg made up, you know, that this is fiction, that people can really treat people this way, that this is fiction. So it's been a growing up moment over these last years. Whether or not they won Academy Awards or not, of people to come to grips with the past in America. This is not a fiction story. The ending is what it is. And so these reflective moments, people have looked back, and young people like you're able to Google it and pull up the images and so forth. And last week's March is really commemorative. So we're in this commemorative time period where we're looking back at a lot of this. There's a lot of pain and anguish. And so when I thought about, well, you know, over these last couple of years, there's so many. In March of 2013, we commemorated the 50th anniversary of Gideon versus Wainwright. You've studied it. I mean, there, the Supreme Court unanimously held that a defendant facing serious criminal charges had a right to counsel. You know, you looking at now are like, what's up with that? I mean, I thought that was always the case. No, it wasn't always the case. It's only in the Gideon case in '63. And so as we look back to see the importance of people having a right to counsel, and so we celebrated the 50th anniversary of Gideon as we deal with issues of access to justice, of people who don't have lawyers, who are underrepresented. All of our states face issues of access to justice where people don't have lawyers. And so we look to the bigger firms like K&L Gates and other firms to dedicate time to associates, to do pro bono work, because though Gideon says what it says, it doesn't mean automatically that justice is there for people. So as we look at these commemorative moments, it's not just to say, hey, isn't that good what the Supreme Court did? It's like, what does it mean today? Are people getting representation? Are they getting great representation? We get all three of my states are death cases. I can't tell you how many death penalty appeals where ineffective assistance of counsel is at issue. They got a lawyer, but it's some really poor lawyering that's going on there. So these issues, though marked by commemoration, haven't ended. And so in August of 2013, celebrating the March on Washington, I was 13 years old, and I remember, you know, watching all this stuff on TV, and John Lewis spoke then, and then he spoke at the 50th anniversary, and he reminded us that, you know, standing in the shadow of Abraham Lincoln, you know, 150 years after the Emancipation Proclamation, they're still here with 200,000 people out here on the reflecting pool marching, you know, trying to get a bill passed, you know, despite all these issues that are going on. And of course, the country's riveted by the famous I Have a Dream speech by Dr. Martin Luther King, in which he tried to focus on the conscience of America, get people to do what? The right thing, because it was the right thing to do. But all at the same time, remembering the people who were being beaten, dogs set upon them. You know, Medgar Evers, you know, assassinated in his driveway. The 4 little girls in the 16th Street Baptist Church murdered. All this while the euphoria of the march was going on, people were still doing dastardly things. And so commemorating the march brought back a lot of these hard memories of that. Yes, in 50 years, great progress has been made in this country, but thinking about where we've come from. And so 50 years later, to be sure, life is better. I surely wouldn't be standing here as chief judge of my court and all the things that I'm able to do and that many of us are able to do. So no one should deny the fact that enormous progress has been made as we've moved along the journey. But that said, the reflective moments ought to be ones of sober commitment and recommitment and dedication. In July of last year, we commemorated the 50th anniversary of the Civil Rights Act and all that it took the most sweeping legislation since Reconstruction. The Civil Rights Act prohibited discrimination of all kinds based on race, color, religion, national origin. And this law finally provided some teeth to the federal government to help end desegregation. Earlier in 1964, the 24th Amendment abolished the poll tax, originally instituted in 11 southern states to make it difficult for blacks to vote. Throughout last year, there were numerous programs and activities that were devoted to these milestone events occurring during the time. And in March of this year, just last week, you saw it on TV in Selma, Alabama, the Edmund Pettus Bridge in Selma, the site of what later became known as Bloody Sunday. There was President Obama and his family, President George W. Bush and his family, numerous elected officials and citizens, as you watch the black and white news clips recreate what had transpired just 50 years ago on that bridge. But that was the catalyst to the adoption of the Voting Rights Acts of 1965. These depictions have both, for older people like me, brought back some tough memories of what else, and for younger people like you, educated you quick time as to events that have occurred that seem like a long time ago, but that they weren't. Perhaps the last commemorative that for this calendar year may be at the end of this year. It's in December of 2015, which will mark the 150th anniversary of the abolition of slavery through the 13th Amendment of the U.S. Constitution. And it would seem, yes, Abraham Lincoln issued the Emancipation Proclamation, but if you study your history, you know that did not free all the slaves. He knew that it would take a constitutional amendment, and it took a while. The Senate passed it. It took a while for the House, but finally it was ratified by the states in December of 2015. So I suspect that there will probably be events that will commemorate those events as well, because they are milestones in America's history, and it is important that we look back and reflect on where we've come. But our reflective moments about these milestones of civil rights history are incomplete, in my view, unless ample attention is given to the lawyers and judges who were toiling in the proverbial trenches when. You have to understand that, this is a struggle, and it's sort of like a war where there's, air power from the Air Force, the Marines on the ground one way, the Navy in the water, on the sea, and the Army plotting. Well, this is like a struggle. There was no one avenue to the approach. Dr. King and those who were on the ground were doing sit-ins, nonviolent demonstrations, etc. But there were the lawyers. There were the lawyers who were toiling in the courtroom to bring about change, to be the proverbial social engineer that Charles Hamilton Houston talked about. And so it's the focus on the legacy of those lawyers and judges that you here at Howard as part of this lecture, while we're in this reflective moment, to me is important that we look to see how this all happened. These were people who were the consummate social engineers. The Brown team, as they were known, was an incredible brain trust, equipped with vast arsenal of oratorical and written talents, pragmatism, vision, dedication, energy. They were courageous, they were passionate, they were intelligent, drawn together in a powerful and a historical collaboration. Now, anybody who's worked with people, particularly smart people, ought to recognize that there are a lot of bad things that can happen when you get a room full of very smart, big ego people together. And not all of it is good. I'm sure that in academic spheres and other arenas, when you get a lot of smart people who are used to having their own way, who've never been wrong, they were first in their class, they know everything, their way is the right way, you have a challenge on your hand in order to try to navigate toward the common goal. This happens in many arenas. It certainly happens on my court. I can tell you, you get 17 judges, Article 3s with lifetime tenure, who all are smart, and it's that way, you got a challenge on your hand. Once upon a time, my hair was black. It's not now. But at any event, it's a challenge trying to manage all those egos. And so for all the good and the glory we say about the Brown team, it was a formidable deal for all these very smart lawyers locked up in a room to come to agreement. But they were, and to me, that's the genius of it, that, of course, Thurgood Marshall at the top of the team, the director counsel, you know about Thurgood Marshall and his history, but others on the team. Robert Carter, who was his deputy, graduate of Lincoln University, and of course Howard, later became general counsel to the NAACP, and a U.S. District Court judge on the Southern District of New York. Spotswood Robinson, also of Howard, Hasty, and Houston. He later served on the U.S. Court of Appeals and was dean of the Howard Law School. Oliver Hill from Virginia received the Presidential Medal of Honor. These were the trial lawyers who were in the trenches trying these cases. And then it was a diverse group. Jack Greenberg, later of Columbia Law School, dean of the College of Columbia, later became the deputy director of LDF, or the Ink Fund, it was called. If you're interested in some of those adventures, read his book. He wrote in 1994 called Crusaders of the Courts. It's very interesting just reading about how all of this transpired if you're interested in this collage of personnel. Robert Ming, a graduate of the University of Chicago School of Law, Howard Law professor, James Nabrit Jr., who this lecture is named after. And you know his background, having practiced actually down in Houston, partner in a firm and representing a diverse group of clients, dean of the law school, president of Howard University, ambassador to UN, and even his son, James III, who joined the Ink Fund when he was right out of law school, graduate of Bates College and Yale Law School. George Hayes, who was, you've heard, lead counsel in the Washington case, Brown University, Howard Law School. This was, to me, the A-team that was putting this deal together. And to me, not enough accolades is given to the amazing prowess that this group of lawyers. William T. Coleman was 94, still counsel over at the O'Melveny firm. And I know that he, at the 8th Nabrit lecture, was a lecturer here. You've probably heard his story, his wonderful book, Counsel for the Situation, Shaping the Law to Realize America. One of my prior law clerks gave me that book upon their exit, and I've read it, and it's just a wonderful book to look back and reflect. He's a man, 94 years old, and he was atypical because he was #1 in his class, finished at Harvard. He was the first African-American law clerk for a justice of the United States Supreme Court. A lot of people wouldn't even know that. And so here he brought a different perspective to the Brown team. If you read his book, he talks about the difficulty of juggling his life between his law firm in Philadelphia, riding the train and trying to deal with his clients and so forth, yet meeting the Brown team in New York, working on strategy and so forth. And so he brings to mind just how diverse this group was. Charles Duncan, whose pictures out there on the wall. And then you had Lewis Pollack, you know, another white, graduate of Harvard College and Harvard University, later dean of the Yale Law School, dean of the Penn Law School. Charles Black and Jack Weinstein later became a judge on the U.S. District Court for New York. And when I was going to law school, it was Weinstein on evidence that you knew. But this was just, to me, a brain trust of people that were brought together. But the last one that I want to mention and emphasize is Constance Baker Motley, because she was the only woman that was in that mix. Maybe that's why the egos didn't get too far out of hand, because she was just the common effect. But she was noted to be calm and cerebral. She joined the LDF as a housing specialist. She was the first female African-American federal judge and handled those cases. But let me tell you why I mention it, because my trip down memory lane, Brother Dennis, is just when I was 4 years old, my dad was a 28-year-old letter carrier working for the post office and working other odd jobs. And his dream was to buy a house, to buy a home for us, me and my older brother, there in town. And there was a subdivision that was coming up called the Clark Terrace subdivision, to be named after the former president of Southern University. And so this was a cooperative in which you paid your $300 deposit, you paid $3,000. And so this was going to be developed there in Shreveport to do it. And so it went along. And so he paid his money and so on and so forth. And so there was a group of people with the Emmanuel Baptist Church and the Floral Civic Club that found out that this subdivision was going to be built. And they said, no, that's too close to our church. That's too close to us. You can't do that. And so they launched vehement opposition to the building of the subdivision, to the point that they were able to get the parish council, the police jury, to pass a resolution to not hook up the houses in the subdivision with any water or other utilities. Now, can you imagine trying to sell a house that's not going to have any kind of utilities to it? But the resolution there, I have a copy of the resolution. I've been through the archives. I've got the pleadings. I got the resolution. I got the affidavits. I got the evidence. So I'm not telling you something that I made up. This is something that my 89-year-old dad, who's still alive, can talk about that case. And so they reached out and they searched for help. How do we deal with this? And so they reached up to the Ink Fund. And so they sent Constance Baker Motley down, a housing specialist. And she was the lawyer who came down in the records to represent my dad. He was the lead plaintiff in a class action against them to get the housing gun. And I looked at the pleadings. They're well filed. You've heard her background. All the pleadings there are filed. They asked for injunctive relief, relief under the due process clause, equal protection clause. It's well pled, even under today's standards. It was filed in the district court, and so it's assigned to the chief judge of the district court, Judge Ben C. Dawkins Jr. And instead of giving them a hearing on their preliminary injunction, instead he advanced the defendant's motions for summary judgment onto the hearing. And so, to make a long story short, in 23 lines with 18 footnotes, he dispatched the lawsuit and said that the plaintiffs had no remedy at law, that the plaintiffs had, that there was no liability. And so it's an abyss in a footnote. A recalcitrant racist judge who, despite an undisputed stipulated record, denied relief to the plaintiffs. And so we never got the house. We never grew up in that house or a house. The houses were redesigned and they were sold to whites only. That's the reality of what the Inc. Fund lawyers and these judges were up against. Though well pled, you still had people with Article 3 tenure and others who were obstinate to grant any kind of relief. And you have to consider the fact that here were a group of lawyers that were representing people for low pay, no pay. You know, this was not a retainer deal. Most of the clients they had didn't have any money. There was no brokerage. You know, they traveled to places like Shreveport. It probably wasn't any too much easier to negotiate around that end as it is now. But there was no taxer. There was no Uber. I think Uber's taking me to the airport, right? Uber's taking me to the airport. What's up with that? I mean, I got the Uber app on my smartphone. You know, it's the best thing going. Taxi companies don't like it, but, you know, they're good to go. There was no Uber. So when Constance Baker Motley came, you know, she had to have drivers. My dad was her driver, and he's talked to us, telling these stories about driving her around and what she went. You can imagine what she went through as an African-American and as a female in a male-dominated world. Yet she was vigilant. She was focused on the task of what she had to do when she came. And so you had these lawyers, Inc. Fund, going into these hostile southern towns, no place to eat. The good little ladies of the church fixing plate lunches, all them chicken dinners and fried fish and okra and greens and cabbage and cornbread, sweet potato pie, all that kind of good stuff. Y'all don't know nothing about that. That was the good stuff. You know, that's the pay. You know, they got to eat good, and they went in there, but they were aroused and they were inspired. And this is why they did it. This was the passion. This was no, if you can't pay me, here's your file. This was dedication to the cause. That's the kind of zeal. And so the templates was, so this A-team had to have it together just to get to court. Just to get to court, and you meet the Judge Dawkins of the world, and no matter how well you got together, you got to deal with it. So that shifts gears from the lawyers to the judges. And so in the couple moments that I have left, I want to shift it to the other part of that fulcrum of Johnson. That's the judges. Even though the people thought, well, if we pass the Civil Rights Act, all will be good. People will obey the law. I don't think so. Any more than people obey the speed limit. You know, it's there. Folks still are texting while they drive. Don't drive with seat belts. And then a lot of the other things are not making it mundane, but sometimes the disobedience was that. And so it was not difficult to figure that refuge would be found in the federal courts, and that progressive judges like those of the Fifth Circuit during that time made that refuge tangible. And so on my court, the Fifth Circuit, then a huge burden fell on them, and they later were known as the Four because they were ones who were at the vanguard of the civil rights issues. And these judges and their decisions shaped civil rights jurisprudence throughout the South, despite some vehement dissenters along the way. One of the judges on the court was a Judge Ben Cameron of Mississippi. And when you read the history, and as Danielle said, I love reading the history. And I guess since I've become chief judge, I've seen all these names. I kind of want to know about all these people. So before we have some kind of commemorative deal on these people, I don't like reading the bio because I just might want to skip any adoration to somebody who's got too many ghosts in the past. And so I try to do my little homework. And where they're there, I kind of just, you emphasize the positive. And as the old people say, if you don't have nothing good to say, just don't say nothing, right? So, but they're there. But just reading these stories. And so people didn't just come off the block. But I mean, these people who made it pretty evident they didn't like us, and they weren't about to give us no relief. And they were still with Article 3 lifetime tenure. So what you going to do with it? Nobody was going to impeach him for not doing it. And so this was the atmosphere at the time. If you want to read more about it, you can read a case, Armstrong versus the Board of Education of Jefferson County, Alabama, 323 F. 2nd, 333. It's a 1963 case in which there's a huge rancor and tension on the court because of the work of the four who were castigated for moving forward as activist judges in the arena of civil rights. But if you read the history, read Jack Bass's book, Unlikely Hero, and you'll hear particularly about these four that I'll quickly identify. Elbert Tuttle was the chief judge of the Fifth Circuit during the most tumultuous time. He was appointed to the court just a few months after the Supreme Court decided the first Brown versus Board of Education case in 1954. And as soon as he assumed office, the Fifth Circuit was in the eye of the storm. He was a Republican from Georgia. He had grown up in Hawaii and attended multiracial schools there. His upbringing gave him a unique perspective on civil rights, especially from the rest of the circuit, who largely had Southern roots. And although he was born in the South, he found little to nothing appealing with the white Democratic Party in Georgia. And he recognized that the South had stagnated politically because of the one-party system. And so he recognized that one of the key facts about civil rights is that resisting change, time is what counts. And so with this, he pushed the Fifth Circuit to move ahead on these issues because the Supreme Court's reluctance to exert leadership created a void that the Fifth Circuit filled. There are many books which detail the opinions that were written by the Fifth Circuit in that era, but he believed that the court had a duty to move forward and breathe life into Brown and the other cases. Known for authoring painstaking opinion was Judge John Minor Wisdom, who's heralded by many of the great opinions of the Fifth Circuit. One of his most prominent works was the 60-page majority opinion in United States versus Jefferson, and I commit it to your reading, in which he laid out specific procedures for public schools to follow in order to be compliant with Brown. And he said, quote, "The only school desegregation plan that meets constitutional standards is one that works," close quote. The landmark opinion set the stage for further desegregation cases, and as he said, the clock had ticked the last tick of tokenism and delay in the name of deliberate speed. John Minor Wisdom's name is on our court building. It's called the John Minor Wisdom United States Court of Appeal building, and in May of this year at our Fifth Circuit Judicial Conference, we will celebrate the 100th anniversary of that building and look forward to doing that. He was a scholar on the court and made a huge impression on Chief Judge Tuttle. He was appointed to the court in 1957 and remained active well into his 90s. In 1992, I had the privilege, in 1994, I had the privilege of sitting on a panel with him when he was 92 years of age, and it was just a wonderful thing. Three of my renegade law clerks, the moment wasn't lost on them. It's the last time I've ever had all guys clerk for me. But the deal wasn't lost on them, and so I sat with Judge Wisdom those 3 days. They hired an artist from the French Quarter that does these artist work. So anyway, the artist sat in the courtroom those days, and I didn't pay any attention to it because, as it were, even though I was junior chronologically on that panel setup, I ended up being senior, sitting in the middle with Judge Wisdom to the right and a junior judge to the left. So they had the artist do a rendering of that panel sitting with me, Judge Wisdom, etc. Of course, the clerks had the temerity to have themselves painted into the photo. So as it hangs in my picture, you would think the clerks, actually there, but they weren't. But the point is that a Sigma, I haven't hired all guys since, but at any event, it was a signal moment, of being able to sit with him because of the genius that he had in the entire. And the third judge was Richard Reeves of Alabama, who was born to plantation-owning ancestors who lost everything in the Civil War. And one might have thought, given his background of a segregationist family, etc., that he would not have been one of the four. But despite that, his ideas changed, and a lot of his focus on race changed because of his son, who was Harvard educated and persuaded him to read Gunnar Myrdal's An American Dream, and that cost him, and he then had deep regrets about what had been inflicted in the South, and so he became one of the four. And the last of the four was Judge John Robert Brown, who was from Nebraska and became a tower of strength in the critical years of civil rights decision. He was an admiralty lawyer, tax lawyer, didn't know anything about this, but these judges were just amazed at what they encountered. And so this four, as they became known, were really at the vanguard. And at that time, the Fifth Circuit consisted of 6 states: Alabama, Georgia, Florida, Texas, Mississippi, and Louisiana. And there were 9 judges on it. It was the largest and busiest circuit in the country. And so most of the segregation work that the Brown was doing was in the Deep South. So this was the trench work area of where. And so although these judges faced death threats and all kinds of stuff, they were anchored in knowing that they were the only things that stood between maintaining Jim Crow and moving forward. And so I conclude with the thought that the excellence of the Brown team's legal skills and their steely resolve to permanently alter the civil rights landscape in America was directly responsible for the many court victories that they attained. Though chronologically young and often out-resourced by grizzled, mean-spirited court opponents and thwarted by stubborn racist judges, the Brown team kept their eyes on the prize. Excellence was their trademark in strategy, brief writing, and advocacy. The biographies of several of these legal giants highlights their level of preparation. They knew that average would not get it. Mediocre was not selling. They were not there just to get by. They knew that only by bringing their A game to the fray every day would they have even a sliver of a chance to realize victory. And so they were there for the tough. It is reported that in their strategy meetings, each lawyer knew the very last footnote of every opinion of the Supreme Court and every decision of a state or federal court having to do with race. They knew all the civil rights statutes from the first one enacted in 1866 and every opinion interpreting them. Finding solutions to the many current events, social, economical, and political issues of the 21st century will require brain power, courage, and tactics that are adaptable to modern situations. Nonetheless, the key social engineers attributes of the Brown team are ones that you, as budding lawyers, will have to inculcate. Yes, we have cyber world. Yes, we have Twitter. Yes, we have Facebook. Yes, we have all that stuff. But in and of itself, they're only tools. The resolve, the passion, the commitment that those lawyers had, that's what you're going to have if there are going to be any real differences in the post-Ferguson, post-Selma, post-world. The issues out there are not going to solve themselves. The lawyers and judge giants of the civil rights era shared an incredibly uncompromising zeal to promote and achieve equal justice under law for all in the face of strident, hostile, often violent opposition by individuals and groups who had decades of presidential leverage reinforcing the bill. And to be clear, the evils that there don't present themselves in the typical way. Very smart people want to intellectualize away rank bigotry by putting some intellectual spin. Even in the case I gave to you of Clark and my dad's case, the lawyers put forth the idea, well, we're denying the utilities because there are other people throughout the city that have asked for these ahead of these people, and it would be unfair. Which has nothing to do with reality. And so in the world I work in and when you are, you're not going to see people coming in saying, well, yeah, we're denying you because you're this or that. It's going to all be in a nice, neat intellectual package that unless you have the brain power to untangle it and call people out for what it is, they will just move on down the road. And so that's why you got to up your ante and have your A game. Your brain can't be infused with anything but what God gave you with, because you got to be sharp 24/7 all the time. If you don't, you will let down the legacy of Brown versus the Board of Education. When I come to Washington, one of the things I like to do is to go out to the monument where Dr. King is. And one day it dawned on me, the way that he's facing, he's standing there like this, but his back is to the Lincoln Memorial. And I feel like the reason is because Lincoln dealt with the 13th Amendment is done. It's not likely slavery will return. But Dr. King is looking out over the water at the Jefferson Memorial. And his arms are folded and his eyes are agaze, which tells me that he is looking at the proposition that all men are created equal. And that his eyes are still focusing on the Jefferson Memorial because it wasn't clear to him that he could dare afford to shut his eyes that all was done. And I say to you symbolically, just as that statute is peering out to see whether previously won victories will be snatched, the legacy you have to claim is to pick up the torch, to take the proverbial baton and move it on down the road, to use the tools of the 21st century, but to be every bit as passionate, as vigilant, as willing to delay gratification, willing to give up some of the bling in order to help people who need help. If you don't help them, they won't get help. And if anybody who's achieved anything isn't spending some time giving it back to young people or people who need it, to me, they're not worth the salt for what it is. Those who bled and died didn't do it for me to just say, look at me. They bled and died so that the torch could be passed to you. Good soldiers like Elaine Jones will always live in my heart. And she called me up and said, we got it. We got it. They sent in your name to the White House. She just walked in. You know, it's like church. You call it in on them when they come in late. But you call it in on them. But Elaine's always dear to my heart because it's people like her with the Ink Fund who fought those victories. And I turned 65 in January. I used to think that was antiquity. Well, I have a totally different perspective on it. Yeah. But as old as I get, and I'll sit down, I will just never forget and be grateful for the Elaine Joneses, the Ink Fund lawyers, and those who toil. And I think one of the greatest tragedies in America is if you forget or fail to know what the legacy of the Brown team and the judges of the Fifth Circuit was and carry that forward to the next generation. Thank you. God bless you.